H.R. 2056, a bill to require the District of Columbia to comply with federal immigration laws.
Without objection, the bill shall be considered as read and open for amendment at any point. Without objection, so ordered. The chair now recognizes himself to offer an amendment in the nature of a substitute. The clerk will please designate the amendment.
An amendment in the nature of a substitute to H.R. 2056 is offered by Mr. Comer of Kentucky.
Without objection, the amendment is considered as read, and the substitute will be considered as original text for the purpose of further amendment. I now recognize the sponsor of the bill, Mr. Higgins, for his opening statement.
Thank you, Mr. Chairman. We recently have had extensive hearings regarding the negative impact of sanctuary city policies. In the District of Columbia, our nation's capital, is of unique significance to the entire nation and should reflect the best policies of enforcement of local, state, and federal law and the immigration policies and laws of the United States. The reality is, however, Mr. Chairman, is that the District of Columbia does not reflect those law enforcement traditions and the professional understandings and agreements between law enforcement authorities across the country at the local, state, and federal level, wherein cooperation is the standard norm. The sanctuary city policies removes those cities from the historically very effective operations of law enforcement, wherein a jurisdictional authority that has possession of an offender, if there's a warrant for that offender that's been issued and is legitimate and has been communicated from another jurisdictional authority, then there's a cooperative effort across law enforcement. Sanctuary cities don't do that. So my bill forces the District of Columbia into compliance with federal law. It nullifies any statute, ordinance, policy, or practice of the D.C. government which restricts any entity or official from providing citizenship or immigration status to federal, state, and local law enforcement, or from complying with the lawful request by the Department of Homeland Security under Sections 236 and 287 that regards the apprehension and detention of aliens and the powers of immigration officers and employees. Is all under the Immigration and Nationality Act, including complying with detainers or notifying at the point of release of an individual, wherefore that release will be directly to the security and control of DHS if a proper detainer has been noticed. The bill also provides safe harbor for individuals who come forward as a witness to or as a victim of a crime, wherein specifically in the legislation, Mr. Chairman, any human being that is witness to or victim of a crime would not be subject to further enforcement if it's specifically under this law. Like this, the D.C. would not be considered not in compliance with this law if they're protecting the identity of a victim or a witness to a crime in an ongoing investigation. So in summary, Mr. Chairman, this bill would be opposed by our colleagues across the aisle, no doubt, but it simply brings the nation's capital into compliance with the nation's laws and with the standards by which law enforcement at the local, state, and federal level have a long-standing relationship of cooperation. It forces our nation's capital to be in compliance with those standards of norm. Mr. Chairman, I thank you for the consideration of this bill in today's markup. I urge its support on both sides of the aisle, and I yield.
Gentleman yields back. Chair recognizes the ranking member for his opening statement.
Thank you, Mr. Chairman. Before I discuss my opposition to this bill, which my friend anticipated, I must ask, are House Republicans trying to sabotage the operations and finances of the District of Columbia, and to what end? The recently enacted continuing resolution cut D.C.'s local budget by more than $1 billion. If that stands, D.C. will likely have to lay off first responders, police, fire, teachers, and Fitch Ratings placed D.C., because of no action on their own, on a rating watch negative. Every CR for the last 2 decades contained a provision that allowed D.C. to spend under its current local budget during the CR. House Republicans omitted that this year. Let's be clear about the absurdity of this situation. D.C.'s local budget consists of local funds, not federal. D.C. raised its own fiscal 2025 money. That money is in D.C.'s bank account. D.C. has been spending that money for 6 months, and now Congress has ordered D.C. to abandon its strategic priorities and investment opportunities. I served for 14 years on the Fairfax County Board of Supervisors just across the river in Virginia, including 5 years as chairman, like being mayor. I cannot imagine running a local government subject to the whims of a dysfunctional Congress. There's been a bipartisan agreement on this dais. We want D.C. to be safe and prosperous. The Senate passed a standalone bill sponsored by a Republican member to fix treatment of D.C. in the CR. That bill is within this committee's jurisdiction. I urge our Republican majority in the committee to work with Republican leadership to bring that bill up immediately. Now let me turn to the bill before us, which I strongly oppose. D.C. should be free to govern itself. My friend from Louisiana has no more business telling them how to run their business than I do from Fairfax, Virginia. The bill nullifies D.C. laws and policies that, like those of other jurisdictions, are in full compliance with federal law. They do not obstruct ICE from carrying out its duties, and they are backed by evidence demonstrating that they keep people safer. Counties with laws that do not honor extrajudicial warrantless civil detainers had significant lower levels of violent crime than counties that do not have such laws. Mayors, police chiefs, sheriffs, local leaders have made clear that the way to combat violent crime is allowing local police to do their job of ensuring public safety in their own communities, not commandeering them to spend limited time and resources rounding up and detaining nonviolent immigrants who pose no threat. The committee has a hearing on this issue. That hearing accomplished none of the majority's objectives, which were primarily to demagogue immigration enforcement policies in large urban areas. Instead, that hearing showcased American cities that were focused on public safety and complying with federal immigration law without getting dragged into the costly business of the Trump administration's cruel, unconstitutional, and inhumane immigration policies. That hearing failed to force the Trump administration immigration enforcement operations down the throats of American cities, so now Republicans are turning their eyes to a vulnerable Washington, D.C., where they are hoping to press the hobnail boot of the federal government that they control to the throat of the nation's capital. It's a shameless moment, and it's one I cannot support, and I oppose this bill. I yield back.
Tillman yields back. Chair recognizes Mr. Biggs.
Thank you, Mr. Chairman. I support Mr. Higgins' bill and the ANS offered by the chairman. I'm going to focus just on 2 brief aspects of this. And Section 2, subparagraph A2, requires compliance with lawfully made. That should not cause anyone heartburn. It is a lawfully made request pursuant to 236 or Section 287 of the INA. And then it's a new or a diversionary tactic that we're seeing now, but what has happened here that Mr. Higgins has done that I think addresses and should assuage much of what my friends across the aisle have traditionally raised, is he has provided a safe harbor for those who are witnesses or victims who wish to come forward, so that there can be no other action against them. So with that, I think Mr. Higgins' bill is strikingly good, necessary, and appropriate at this time, and I'll yield to the gentleman from Louisiana, Mr. Higgins.
I thank the gentleman from Arizona, and I respect the ranking member. It may surprise the nation to know that he and I have a very friendly and respectful relationship. And I respectfully would remind the gentleman that the District of Columbia is indeed unique amongst all municipalities in the country, for it is our nation's capital. And Congress does indeed have authority within the decision-making process of the District of Columbia, and we have ceded some of that, to be sure, for local affairs. But the interaction with federal law enforcement, as it relates specifically, in this case, to the removal of illegal aliens, this is certainly a federal consideration, and therefore our nation's capital should be in compliance with federal laws and should be exemplary therein. However, that's not the case. And the gentleman knows that laws are written, statutes are written at the local, state, and federal level with words like may and shall for a particular purpose. This just removes discretion. This shows the severity of the intent of the statute as it was written. And under the Code of the District of Columbia, 24-1107, the prohibition on cooperation with federal immigration agencies, the District of Columbia shall not hold an individual after they've been otherwise released to comply with an ICE detainer request, provide any facility or equipment to assist ICE with a search or inquiry about an individual in D.C. custody, permit ICE to interview a suspect in D.C. custody unless compelled by court order, provide ICE information about an individual's release date or location or any information about why they were detained, grant access to federal immigration authorities to District of Columbia detention facilities, or inquire into the immigration status of an individual in custody. D.C. laws go on with similar sanctuary city policies, prefaced by shall not or will, not may or can. No discretion there. These laws were written with severity leaning towards sanctuary city policies, and our nation's capital should not reflect a refusal, in fact, a mandated denial of compliance with federal immigration law. I thank the gentleman for yielding me some of his time, and I yield back to the gentleman from Arizona.
I thank the gentleman. I yield, Mr. Chairman.
Gentleman yield. Any other members? Chair recognizes Ms. Norton from Washington, D.C.
Thank you, Mr. Chair. I strongly oppose this undemocratic anti-immigrant bill, which would nullify duly enacted laws, policies, and practices of the District of Columbia. Before I address the details of this bill, I want to discuss democracy and the lack of democracy in D.C. The Revolutionary War was fought to give consent to the governed and to end taxation without representation. Yet more than 700,000 D.C. residents are denied voting representation in Congress and full local self-government, even though D.C. pays more federal taxes per capita than any state and more total federal taxes than 19 states. Last Congress, Republicans introduced more than 100 bills and amendments to repeal or block D.C. laws and policies. This Congress, Republicans have already introduced 17 such bills and amendments. 2 weeks ago, Congress passed a bill drafted by Republicans that cut more than $1 billion from the D.C. local budget, which consists entirely of locally raised revenue. Although Congress has plenary authority over D.C., Legislating on D.C. matters is a choice. In 1953, the Supreme Court held that, quote, there is no constitutional barrier to delegation by Congress to the District of Columbia of full legislative power, end quote. D.C. has a local legislature. The members are elected by D.C. residents. If D.C. residents do not like how the members vote, they can vote them out of office. That is called democracy. The voting members of Congress are elected by residents of states. If D.C. residents do not like how members vote on D.C. local matters, they cannot vote them out of office. That is the antithesis of democracy. Congress has the authority to grant D.C. residents full democratic rights. It simply needs to pass my D.C. Washington, D.C. Admission Act, which would make the residential and commercial areas of D.C. a state. The merits of D.C. local laws and H.R. 2056 are irrelevant, since there is never justification for Congress interfering in D.C. local matters, but I will briefly discuss them. Consistent with federal law, D.C., like states, cities, and counties across the country, has passed laws to support and protect the safety of all its residents, regardless of immigration status. In passing such laws, D.C. followed its values and the evidence on the benefits of such laws for the entire city. House R 2056 contains an exception for victims and witnesses to crimes. The exception is a fig leaf. If enacted, the bill would deter immigrants from seeking assistance from or cooperating with the D.C. government, including the police department. I urge members to vote no on this bill.
Ask my friend to yield.
Go ahead.
Yield to Mr. Conley.
I thank my friend. I just want to say local control is best. And I say to my friend from Louisiana, and he is my friend, I don't think Baton Rouge would like Congress telling it how to do its policing or its fire services or other municipal services provided. Neither would my jurisdiction. Neither does D.C., which is 700,000 people. We either believe in the principle of local control or we don't, even when we disagree with decisions they make. God knows I've disagreed with decisions made in D.C., but I've never tried to interfere. I've never presumed. If we're going to go down this road, why don't we take over zoning? So we can do zoning for D.C. We can decide on the building height limit. We can decide on where commercial goes, where residential goes. We can get involved in the geothermal experiment, which is exciting, and do whatever we want to do about it. We can really tie up this committee with a lot of D.C. business that belongs in the hands of the locally elected, empowered D.C. City Council. And I believe very firmly in that principle. I have never tried to overturn or legislatively question a decision made by that council. It's not about my personal preference. It is about the democratic will of the people of the District of Columbia, 700,000 fellow citizens. I urge defeat of this bill, and I thank my friend for yielding.